Yep.
When you have someone who's elderly that passed away, it's going to get messy. And a lot of people will just exclude things that seem inconvenient. And this blows up later. This really, really blows up later. So sometimes they won't mention that there are predeceased children, right? The decedent had 5 children. One of them died when they were 8 years old, but they just don't mention it. Well, but now we have to do a whole new petition. We have to, change it and refile it and etc.
Yep.
Okay, what if the child died at 40 and had 3 children? You can't just leave them out. They're going to get his share, or they at least need to get noticed the way he would have needed to get noticed.
Hey guys, welcome back to the Probate House Guy Podcast. I am Brad Woodall, the Probate House Guy. Today we are continuing our series where we're having an attorney from all 50 states on the podcast. And today I have Yana Feldman from New York City on the podcast to talk about probate elder estate law in New York. So Yana, welcome to the show. Thanks for joining us. Why don't you tell us a little bit about yourself?
Thank you so much for having me. So I am an attorney in New York City. I've been practicing 20-something years. And today, my firm, we have a team of 11, and we handle estate planning, elder law, Medicaid, and trust and estate administration. So we prepare wills and trusts. We help families figure out how they're going to pass their assets on and protect them. And then we deal with the actual transfer when someone's passed away. And a lot of times we're also dealing with transfers when someone's passed away, where the family hasn't planned, where the decedent hasn't done estate planning, doesn't have any documents, and things are not always super clear. That's what we do. And we're in New York City. I'm sitting in Brooklyn, but we work in all 5 counties and the surrounding areas.
Cool. Awesome. Nice. So how'd you get into estate law? Like, what made you, you went to law school? Did you know before you went to law school? Like, what got you into this field?
Well, it's funny because right before you started recording, I told you that I went to law school with a very specific plan. I was going to be a prosecutor. And after 9/11, everything was up in the air, and I started sort of scrambling around and looking for a job. And I had really enjoyed trust and estates in law school because it's all about families and interactions, and it's a soap opera. There's love and hate and jealousy and money and envy. So it's very juicy.
It is.
And my first job was working for a woman who handled nasty contested guardianship litigation. And, you can compare it to child custody issues, or I like to call it probate litigation before the person's dead, right? So it was really nasty, and no one wants to be there. And I sort of went backwards, and I said, how do we avoid this? Well, it's planning, right? It's making a plan. It's not doing it cookie cutter. It's really looking at how your people interact and how they're going to react to things, and thinking about potential conflicts that can come up and planning them out. Like, oh, you want your family to all be able to stay in your house when you're gone? Okay, that's great. How is that going to work? Who's going to pay for things? What happens if they don't pay for things? All of these things. And sometimes the plans change. Like, wow, that sounds really complicated. Maybe they should just sell it and divide it. Or we talk about maybe someone gets a right of first refusal. That my son, who's been living in the house with me, if he wants to buy it, this is how we're going to value it. And he has this long to get financing and buy out his siblings, and maybe he gets a little accommodation, whatever it is. So, I think because we do planning and administration, and we don't do litigation right these days, but we have in the past, we really look ahead to see what's potentially out there, what pitfalls are out there, and how can we avoid them.
That's great. I can't tell you how many deals we have. I mean, obviously with the probate deals, we get the family fighting, but the deals where a family member is living in the property. In fact, we just got a lady called us 2 days ago that she first reached out to us in 2021 to sell this property, right? We got her connected with an attorney and said, you need to go through this. Here we are in 2024 now. She's like, hey, I finally got my letters of administration, but my brother or my sister moved in the house. She's not answering my phone calls. Like, we all want to sell. Like, where do we go from here? You know? And it's like, okay, well, you know, here's what we need to do and whatever. And we deal with that all the time where there's somebody living in the house or brother wants to buy the house, but you and I both know brother doesn't have any money. So setting that timeline, like you said, and giving him a deadline of you have till X to buy it. And if you don't, then we're selling it, you know, like that happens all the time.
And we actually get realistic. I have a matter now where the parent has 2 children. One lives in the house with them. You know, he wants that child to have an opportunity to buy it. And he sort of picked a number because he said, but she's also been helping me, so she should get a little bit of credit for that, etc. And I said, okay, but here's the actual value of your house. And if this is how you divide it, this is what she needs to come up with. Go see your lender and figure out if you will qualify for this. And she came back and said no. And I said, so by setting it up this way, you are making it not possible. So you either need to get around sell and split or change the display. You need to actually, what's the expression, play it out to the end. You know, it's all nice and theoretical, but how do the numbers actually work? What's going to actually happen? Is this person going to be able to get financing, or are you just going to waste everyone's time?
Right. And you got to get creative with it sometimes too, because there's the emotional aspect, like you said, like you're kind of kicking someone out of what they think is their house, right? And you got to deal with that dynamic. I remember I helped a family, it's almost been a year ago now, but, you know, brother and sister inherited property from dad. I think dad was the last person to pass. And then brother's son, there was multiple properties. So the brother and sister lived in their house, and then they had a couple rentals, and then brother's son moved into one of them. And they were like, look, we want, like, brother's or son's been living there for so long. And I helped her. I said, well, why don't you do this? You want your cut, right? So brother wants to help his son out. I get it, right? He's helping his son out. Sell it to son for this price. That's still a really good deal. Like, son's getting this property for a good deal, and she was okay with it. She's like, I'm fine with that. I want to help out my nephew or whatever. So I said, okay, we'll get your nephew. I'm going to help you set up a seller financing scenario. You know that your nephew has a good job, makes good money, right? He's got cash, whatever. He has a construction business or whatever. I said, so make him pay you a down payment. That's your cut. You get that down payment money. And then your brother can collect the rest. And his portion of the down payment is him being a good dad and giving his son a good deal, right? And then you guys just, however you want to split the cash flow over the next few years, you can, or if he wants it. And then and I said, here's how you do that. I'll connect you with my attorney over here. He can do all the documents for you, set up the, promissory note and all that. She's like, I never even thought about that. That's amazing. I was like, yeah, so you get your money, you're out. And then dad gets to help his son out, and all is good, right? Everybody's happy. Win, 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 So.
Yeah. But, when you have a group of people that are actually interested in finding the best solution for everyone, it's much easier, but so much of the time it is emotional.
Yes.
And it's about, but you used to beat me up when we were kids, and or you got my girlfriend pregnant. It's truth. Everything I say is a true story.
You and I could probably talk for hours about all the crazy, like, Maury Povich kind of scenarios of families and drama.
Maury Povich and Ricky Lake and who's the other guy?
Jerry Springer.
Yes, all of it put together.
It's some of these situations are all right out of the shows. Yes, for sure. So, yeah, I mean, that's crazy, but, and you have to be put on your therapist hat, right? So also, I'm sure you got to put on your therapist hat. What do you have, like maybe one or two pieces of advice for families that are fighting, they're going through the probate process, like just a tip or two to like maybe help them get past that, right? Sometimes you can't, but sometimes how do you talk some sense into people sometimes?
Well, I think, so first of all, I have resources for them. And I have literally sent people to family therapists.
Okay.
In New York City, the Surrogates Court actually has a mediation program where there are trained mediators available. Now, I'm not saying anything whatsoever about the quality, but it's a very hard sell to clients.
Right.
I have a woman that I work with, and actually she can work nationally. She's not an attorney. She's actually a professional fiduciary in California. California has a system where your job is to basically be a professional fiduciary, and you're bonded and insured and licensed, and you can be appointed. Sometimes people are concerned that their family members won't be able to do a good job as an executor or trustee, or they don't have anyone of the right age or in the right place. So she can serve. And she's sort of winding down that practice, but she has so much experience dealing with these situations as a neutral party that she has started a coaching business.
Okay.
Where she, her hourly rate is, a lot less than mine. And she works with people in these high conflict situations. How can we problem solve the non-legal issues?
Yeah.
So I think the number one piece of advice is try as hard as possible to treat it as a business financial transaction as opposed to rehashing what happened 40 years ago. Right? Because you can't change that. So that's number one. Number two, I think be as open and direct with your attorney as possible, because the more we know about your dynamics and how your family works and what their motivations are, the more we can guide and advise you. And a lot of people hold things back because they feel like it's not relevant or it's personal or it's embarrassing. It's like you're going to the doctor and you might have to say something embarrassing. I have a bump in a place that gets covered by my bathing suit and it hurts. And, that's not pleasant, but the doctor can't help you if you don't tell him.
Don't tell. Yep. Yeah, I've taught my team members, and we've gone through sales training programs and all this stuff to learn how to like ask the right questions and actively listen to people and pick up on cues, because people will hide stuff because they're embarrassed. Right?
For sure.
It's just embarrassment, really. They're ashamed of it. They don't want you to know, but some of those facts are pertinent to the situation and help you with the problem.
Very pertinent. And you don't know me that well, but I think it's obvious that I try to make people feel comfortable and not too stiff. And, I'm not I don't even know if I own a suit at this point in my life.
That's awesome. I love it. Yeah. I haven't worn dressed up in forever.
I probably should have one, but I lost a little weight. So, right. So I try to make people feel comfortable. And then I make a point of saying, I'm going to be asking you some questions that you might feel are not relevant or feel like they're inappropriate. And I'm sorry if you feel that way, and I use the doctor analogy, the same way the doctor needs to ask you about all sorts of things so they can understand how it all works together, I need to ask you too. And I want to tell you, no matter what you tell me, I guarantee you I've heard worse.
Yep.
I've heard crazier.
Yep.
Your family is not the most messed up family that I've ever met. So I have no judgment. I am here as a professional. So please, please, please let me help you, by giving me that. And then as lawyers, it's very hard for us, but we have to learn to shut up and sit there and let the silence get a little uncomfortable. And then they start spilling it.
That's actually a huge sales tactic. Like
I've also done sales training.
Right. Yeah. So the silence helps, breathe things up, sometimes you just have to shut up and listen. So that's great. So that's great tips right there. So any other tips you have, like if an estate comes to you and they want to work with you, like what should they do to make the process go smoother? Obviously you talked about answering all your questions. Is there anything else, any other tips you have for them to help make the process go smoother?
Are we talking about families or are we talking about investors? Families. Okay. So the first thing I would say is while I absolutely welcome multiple family members to be part of our meetings and our work, it's very helpful to decide who's going to be the main point of contact, right? And, because I need to know who my client is. And sometimes we will do a joint representation. I prefer if we can avoid it, to be honest, because it just makes things messier. But you have to decide who's going to be the one leading the charge. And again, if they say share with everyone, then we share with everybody. But I need to know who my client is. Or sometimes it's two clients and then we have them sign a conflict of interest and etc. But that has blown up a few times. Yes, gather as much information as possible, but I am also very conscious that a lot of the time people don't have information.
Yep.
So, but sometimes anything that you have is useful. Tax returns, you can pull a credit report sometimes, going through their mail, going through their files and their, personal papers at home. If you have access to bank statements, seeing like where money goes in and out, sort of as much as information. The family tree, right?
Yes.
Locating assets is actually much less important for me because they're not going to go poof. The biggest thing is the family tree, because when we have to probate an estate or administer an estate, that's when you use the default New York State will instead of making your own.
Intestate. Yep.
Yes, exactly. The hardest thing is what's called jurisdiction, because in order for the court to bless the will and say, yes, okay, this is valid, and executor, you can go sell the house, pay the bills, do whatever, the court needs to have jurisdiction over everyone that's involved. And everyone that's involved is either, or it's anyone who's listed in the will. So even if it's, someone getting a few $1,000s or a painting or, something like that, we need their name, their address, their phone number. We're going to need to send them a waiver. And this is all assuming that no one is contesting anything. This is a smooth transaction, right? I've had wills where she listed 23 people to each get a simple piece of jewelry. We're talking about like a gold chain that's maybe worth $300, $400.
Right.
And we have to have a waiver.
Wow.
So that plus everyone who's in the will, plus we need everyone who would inherit if there were no will.
Right.
So next of kin. So in New York, if you die without a will, if you are married and have children, it's roughly 50% to the spouse, 50% between the children.
Okay.
If you don't have a spouse, then to your children. If you don't have a spouse or children, then to your parents. If they're deceased, to your grandparents, potentially. And then if they're deceased, to your grandparents' children, who are your aunts and uncles, the siblings of your parents.
Right.
And then to their children, etc. So when you have someone who's elderly that passed away, it's going to get messy. And a lot of people will just exclude things that seem inconvenient. And this blows up later. This really, really blows up later. So sometimes they won't mention that there are predeceased children, right? The decedent had 5 children. One of them died when they were 8 years old, but they just don't mention it. Well, but now we have to do a whole new petition. We have to, change it and refile it and et cetera.
Yep.
Okay, what if the child died at 40 and had 3 children? You can't just leave them out. They're going to get his share, or they at least need to get noticed the way he would have needed to get noticed. Non-marital children. If you know there are non-marital children, you need to include them. And just because it doesn't feel nice and it makes mom uncomfortable, it doesn't matter. If you know that they're his kids, you have to include them.
Yep.
And this is a really, really touchy one. Because not only is it unpleasant, but also they're potentially getting a bunch of money. Right. You know what? If dad didn't want these non-marital children to get a bunch of money, he could have come see me and prepared a will or a trust, which would have avoided even needing to list them on a petition.
Exactly. Yep. Oh, we've had people conveniently omit stuff and then come to us. We did one, our mutual friend, Josh, did this for us. He ultimately ended up getting screwed out of that deal. They didn't pay him. And they didn't mention that their aunt had kids. They said no, aunt didn't have any kids. She wasn't married, didn't have any kids. Well, day before closing, after we finally probated 2 estates of other family members, it comes out that my attorney said, hey, I need a copy of aunt's obituary just to have in our file for the title underwriter. I said, sure, no problem. So we went and found the obituary. So-and-so was survived by 3 kids, and I called the lady that we were dealing with. I was like, you told me she didn't have any kids. Now, this is a problem. We can't close tomorrow because she did have kids, and now we have to find all of these kids and probate her estate. And she got mad and then found another attorney behind our backs and another investor that missed that and wasn't as thorough as my guy. But then ironically, when that guy who bought it went to go sell it, that attorney did their homework and found it, and he got stuck in a title claim mess and all of the above. And I spent thousands helping these people out. They didn't have a pot to piss in. They didn't have any money. I fixed their roof. I paid for their power bill a couple of months, and I got them my attorney to do this kind of pro bono, get paid later. And then they went behind his back and my back, sold to someone else. They didn't know about this probate attorney. He was out $4,000. I was out probably $3,000 of my money. And now that, just completely dishonest. And then she calls me and tells me she's going to sue me. I'm like, for what? I sue you.
So first of all, one of the things that I do, at this point, I don't do a lot of deferred payments. I will occasionally under very specific circumstances, but I don't do it very often. But when I do, I make the client pay something meaningful to them.
Okay.
And I tell them this. I say, look, you want me to go ahead and give you my expertise, give you the time of my team who I have to pay, with the promise that I'll get paid at the end. Now, in my experience, when people have no skin in the game, they are often not very motivated.
Nope.
And they're not great to work with. So I need you to put up something meaningful. And listen, for some people, it's $500. I had one family that would come and pay me $200 every 2 weeks. And they did it. And they were amazing to work with.
That's awesome.
And that was actually also a development deal. Mm-hmm. But they found me directly. So I think that it's very reasonable to ask for clients to invest in the process. And I know that some attorneys are more comfortable waiting to get paid. In New York, it's just such a long process.
Sure.
Sometimes my developers will pay, or, with the developers involved, I'm a little more comfortable.
Sure.
Or, maybe I'll say, okay, can you give me $2,000 now and I'll wait for whatever the rest of the bill will be later, something like that.
Yep.
Yeah. And I won't advance filing fees, which in New York, if you're selling a house, is going to be $1,250. That's just the filing fee to the court.
Gotcha.
Someone's got to come up with it. I'm done. I've done it a lot, and I've got burnt. So
hey, that's how we learn. We get burned sometimes, and unfortunately, there's dishonest people in this world, and they exist.
I don't think most of them are dishonest. I think it just sort of shakes out in a way. But it's easy if they don't have anything to lose. It's easy to be like, oh well, Yana's gonna
my problem.
Get screwed.
Yeah. So great. This is leaning into the next topic here. So in New York, how much does probate typically cost? Like probably a high, medium, and low. Obviously, it could cost a lot for crazy complicated. But your basic case and your average case, what is the cost typically?
So I'm assuming that there's no litigation, right? There's no one who's contesting the will. There's no crazy surprises and non-marital children and, et cetera. I say minimum $5,000 plus filing fees.
Okay.
So budget and then there'll be, some little So let's say about 7,000 all in on a very straightforward estate.
Okay.
Sometimes it's a little bit less. Sometimes I have clients who are very cost conscious, and I tell them that there are things that we usually do that are not really legal work. Things like, finding information on, relatives and arranging for them to sign documents and, things like that, where my paralegals are doing it, but we're billing. Listen, I can prepare the 5 waivers for, you and your siblings and et cetera, and I can send them to you, and you go chase them and get them to sign it and notarize it and send it back to me, and then I don't have to bill you for it. So I try to work with people if they are trying to keep their costs low. And, and we have our legal assistant and our paralegal do as much as possible, and their rates are lower. But I would say, $5,000 in legal fees, and then, about $2,000 in like soft costs.
Okay.
If it gets a little bit more complicated, kind of the next thing is the jurisdictional issue, like finding people. Well, I don't know. I don't know who her, this is a different branch of the family. We've never talked to them. I don't know. Then it can get a lot, even without conflict, it can get a lot more expensive because we do due diligence. We search for them. We encourage the family to search for them. We search Ancestry.com, Social Security Death Registry, all sorts of things. We sometimes will try to reach out to neighbors or friends. Sometimes we have to hire a genealogist, and I have different genealogists based on where the families are from. So I have genealogists that specialize in Jewish families from Eastern Europe.
Okay.
Because there were so many deaths and so many records destroyed during the Holocaust and World War II. Yep. And it's happening now again. And, in Ukraine, they're bombing places where information is stored.
Yep.
So, I have those. I have the one that specializes in Black families from the South, because there were different ways of looking for records amongst different communities.
Sure.
So, that can get very expensive.
Yes.
And if we can't find people, we have to go to court and say either we don't know who the heirs are, they're called unknown heirs, or we do know who they are, but we can't locate them. So then the court will appoint either the public administrator or an attorney to serve as guardian ad litem to represent the interests of these people. And they're going to try to find them. Well, they're going to review, did we do a good job? Did the genealogist do a good job? They're going to make another pass. Then they're going to review the will and the circumstances and the family and say, like, does it make sense that they need to be part of this? Yeah. Or is it really, one of these people that we call laughing heirs who have never met this person, have zero relationship. The decedent wouldn't know their name, wouldn't know who they are. They're the great-grandchild of their cousin, etc.
Right.
So that can make the process much longer, and that can make it much more expensive. So that can go to $15,000, $20,000, and a lot of that is cost.
Sure. Of all of the parties and the vendors and the subcontractors and all the people doing all the things.
Yeah.
So in New York, how long does probate typically take for, like, let's say an easy laydown case, average case, and then, obviously what you described, those could take years, right? But
oh, yeah. I had one case that took 8 years with zero conflict, zero litigation. My family tree was 12 feet long.
Wow.
I had it taped in the scroll. I tell people that in New York City, if we can submit a perfect, complete petition with everyone is located, all the waivers are signed and filed, there's no citation date, which I can talk about in a minute. Mm-hmm. Minimum, best case scenario, 6 months.
Okay.
18, very realistic.
Okay. 18 months. Okay.
Very realistic.
Got it. Okay.
It's getting a little better. It got really, 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 really bad during COVID.
Oh, yeah. Everywhere.
Really bad. It's getting a little better, but it's still not great, which is why I like people to use trust. Sorry.
I was just talking to my dad actually yesterday or this weekend about one of my grandfathers passed away in March. He was 93, lived a great life, whatever. And my other grandfather, he's 87. And my dad was like, hey, and he's starting to talk to his dad about, like, hey, probably let's think about this now.
You should talk to Josh.
Actually, I'm going to have Josh do a trust for him. So that's what I was telling Dad. I was like, I'll connect you with his firm. They'll set up a trust. We'll put everything in a trust, get it. He's got a will and that's great, but like a trust is better.
Let's avoid probate. And then the other thing, which Josh can talk about because Medicaid is different in different states, is you can also, it's great that you have this house that's worth a lot of money, and that is going to go to your children at some point. Wonderful. Even better, you made a will that's going to make it a little bit more clear. And For example, one thing, when we make wills, we take a family tree and we take contact information. Okay. So when it's time to probate that will, we can pull it out and say, this is what we got from the decedent,
Boom.
Now, what if on top of that, you set up a revocable trust so that you can avoid probate and avoid this expense and delay and uncertainty and, et cetera? Even better. But what if during your lifetime you get sick and you need care?
Yes.
And everything goes poof.
Right.
And I have a lot of cases where the family hired me to probate a will or administer an estate, and we got through it and everything was fine. And they were all counting on their inheritance, except guess what? Medicaid comes along and asserts a claim as a creditor. And guess what? They're a priority creditor.
Yep.
So the condo that you just sold for $700,000, where you and your siblings thought that you were each getting, $200 and change. Well, after Medicaid gets paid $400,000 because mom had home care for 12 years and then spent the last few months in a nursing home, they got $70,000 a piece or something like that.
Yep. So great. You mentioned Medicaid. We deal with this quite a bit. If someone is, let's say they haven't passed and they do need to go into Medicaid sponsored assisted living in New York, does the family have to sell the house? Like some states, you've got to sell it. They
New
won't.
York is an amazing place to be old and save money.
Okay, great.
Second only to California.
Yeah.
So Medicaid in New York for elders basically has two programs. There's all sorts of special things, but basically two programs. First of all, in New York, we have an amazing benefit where you can get what's called community-based services.
Okay.
And that means that you can have a home health aide come take care of you in your home, in the community, potentially 24 hours a day.
Wow.
So you might never need to go to a nursing home.
Okay.
And then we don't actually have, Medicaid doesn't really pay for assisted living, but they do pay for skilled nursing facilities, which a nursing home, right?
Right.
So the programs work differently. For the community Medicaid benefit, which is what most people would prefer to take advantage of.
Oh, sure.
There is qualifying can be very quick and easy.
Okay.
There's a limit as to your, I don't want to turn it into that. There's a limit as to how much you can have in terms of resources.
Okay.
And we can set up a Medicaid Asset Protection Trust. We can transfer assets into the Medicaid Asset Protection Trust. And this is only New York, very few other states. As soon as the next month after the transfer, you can qualify for community Medicaid.
Okay.
As soon as the next month.
Wow.
Most states have a look-back period. Most states don't have a very good home care program. There's a waiting list, or you're only going to get 2 hours a day. So New York is very, very special.
Yes.
So now you can have community Medicaid and own a house that's worth up to $1 million in New York.
Okay.
The idea being that, listen, it's your home that you own. You want to stay in your home. Great. We're going to let you stay in that home. You don't have any other money. You don't have other resources. You're under the limit. We're going to provide you with care in your home. But when you pass away, or sometimes even before you pass away, we could put a lien against that property, social service lien, or we come as creditors in the surrogate's court process. The surrogate's court is the court in New York that oversees probate. So I typically will advise clients, even though you can be Medicaid eligible while you own your home and receive community-based services, first of all, if you have to go to a nursing home, guess what? It's no longer exempt because it's no longer your primary residence. And number two, you know, they're going to get paid back at the end. So get it out of your name, put it into a Medicaid trust. Okay. If you need skilled nursing care, what I just explained before, there's a 5-year look back period. So if someone comes to me in their 70s and says, you know, we're worried that one day we might need care, if we set up a Medicaid Asset Protection Trust and put their home into it, after 5, or whatever other assets they wish, after 5 years go by, for Medicaid purposes, those assets are poof. They are non-existent. They are not available. They're not counted. You can shelter them.
Interesting.
When it's been less than 5 years, or, you know, when you don't have that 5 years, when we have what we call a crisis plan, someone comes in and says, my 91-year-old mother needs nursing home care and she has assets, right? Then, you know, well, we earn our money then. Off the top, I will say that you can virtually always save approximately 50% of the Medicaid applicant's assets.
Okay.
Sometimes you can save more. There's loopholes. Was your kid living in the house with you for 2 years before you went to the nursing home? That's a federal loophole, any state.
Okay.
If an elder is living in their home with a child, they're called a caretaker child. And it has to be your legal child, bio or adopted, not your stepchild, not your grandchild that you raised, you know.
Yeah.
You can transfer the home to them without any look back, without any penalty, which is really, really big. I mean, and the reason the states allow this is because, you know, child, you helped your parents stay in this home. You know, we're not going to put you out into the street now. There's another exemption if there's a sibling with, and this is me being a lawyer geek, it's a very specific term. is there is a sibling with an equity interest in the home residing there. So Mary and Susan live in the home together, and let's say they own it jointly, and Mary needs to go to the nursing home. Her share can be transferred to Susan. But here's like the funner loophole for me. They don't define what an equity interest is. And there has been case law where they said the sister was never on the deed, but she contributed money every month that was used to pay the mortgage and the carrying costs. So the surrogate's court is considered a court of equity, for example. We want things to be fair.
Sure.
So you can consider that as equity, even though the sister wasn't on the deed. So there are a bunch of loopholes. And even if there are no loopholes, we can still save a lot of money.
Yeah.
So I'm sorry. I get very passionate about people that worked so hard to, I like doing the $20 million estates too. That's intellectually interesting and you can save millions of dollars. But the people that, just worked and saved and build this legacy, and it's going to make the difference between helping their kids pay for college and graduating without being $200,000 in debt, or helping someone pay for a down payment. My firm is called New York Legacy Lawyers, and the money isn't the legacy. It's what the money lets you do.
Sure.
Right?
Absolutely. Well, it sounds like you have a passion for this. And if I can give anyone any piece of advice and they're looking for an attorney to work with to help with their estate or whatever, find an attorney who has passion. If your attorney just all of a sudden just like their face lights up like you do and you just start going on the tangents, that's awesome, because you know this and like this is your thing, and they need to work with you because like you care about it, right? You're not just trying to make a buck. Like you get that like obviously you make the money, but you also get that kind of, that's your motivation, right? To like
I get a great deal of satisfaction. I was raised by my grandmother. She lived with me and my parents, and I was very, very close with her. And she was actually a Holocaust survivor.
Okay.
And she started getting some reparations payments. And it wasn't a ton, but and I didn't know about this as a child, but she gave it all to my mom and said it was for me. And when I'm sorry, I'm literally going to get emotional now. But when I went to college, at that point she had profound dementia. Like she had no idea what was going on. Right. But when I went to college, my mom said, I have about $20,000 to help pay for college that your grandmother saved for you. Like, who had nothing. She had nothing. She lived with us,
Right.
And, that, I told you I'm getting, like helping people do that, and helping people find the value, maximize the value in their loved one's estates is so deeply satisfying for me because it changes lives.
It does. Absolutely. That's awesome. I love it. So in New York, obviously it's not recommended, but in New York, can someone do probate themselves? Like, is that even allowed? Some states not.
It's allowed. It is allowed. I would never, ever recommend it. What I do sometimes is kind of a super consult where someone is bound and determined to do it alone.
Sure.
And I will kind of print out the forms and I'll explain how to fill them out. I mean, they have all this stuff available on the website.
Sure.
But I listen to, they can't give you any advice. The clerks at the counter, they can't give you any advice. They can give you templates.
Right.
So I sit down with them and we kind of draw out the family tree and what are the assets and who's going to get what. And it's almost like coaching. Sure. I'm not representing them, but I'm coaching them. But it's not ongoing. But sometimes if it's really a very simple matter, that works out well. And it's not rocket science. It's just administrative and bureaucratic. And yes, there are legal issues, but let's assume that you're not coming up against real legal issues. It's just that we know that New York City has 5 counties. Mm-hmm. We know that this county wants it this way and this county wants it that way.
Right.
We know that if you go to the clerk that has the long braids, he's going to want to see this. And if you go to his colleague,
Yes.
who's the lady who always wears the long skirt, she's going to want to see this. And sometimes we come in, we check in, and then we see someone calling and we're like, oh, I have to run to the bathroom. I'll put myself at the bottom of the list because I want to talk to that guy. I don't want to talk to that guy. It's these things. We know the things that, why we know it? Because we've dealt with it, because we've made these mistakes on other people in the past.
Right. You learn through the school of hard knocks on how to get the cases done. And there is value in that. Yeah, they might be hiring you and paying you to do that. But it's just like in real estate, right? People want to get started in real estate and they're asking me about doing deals. And I'm like, guys, you're going to pay for your education one way or another. Whether you pay somebody to coach you or you do deals and learn it the hard way, you're going to pay for your education one way or another. So pay for it now or pay for it later. You choose. That's up to you, right?
Yeah.
In New York, is there a notice to creditors period like many states have?
So once the estate is opened, there is a 7-month period that creditors have. And this is, again, from the time the estate is open, not from the time the person passed away, from the time the estate is open, which means that the court has said, yes, this is all good. Executor, here's the paperwork that authorizes you to act on behalf of the estate.
Okay.
So after that, after those 7 months, the fiduciary will not be liable for distributions made in good faith. So you have to remember that good faith thing. So what does the good faith mean? The fiduciary is the executor or the administrator. The fiduciary has to make a good faith effort to identify creditors.
Okay.
So what does that mean? Well, if the decedent died in a hospital or a nursing home, did you get their medical bills? If they were a Medicaid recipient, have you gotten a bill from Medicaid?
Okay.
Did you, now that you're the executor and you have access to their bank accounts, have you looked at their statements? Have you forwarded their mail? I would say, have you pulled a credit report and, seen what's going on? Do you have to investigate, to the ends of the earth and find every creditor? No.
Yeah.
But you're supposed to make a good faith effort. If you've made a good faith effort and it's been 7 months and no one's popped up and you make the distributions to the beneficiaries, you're not going to be personally liable.
Got it. What about publications to creditors? Do you have to do that in New York? Some states, they require you to post it out in the local newspaper for X period of time. There's nothing. So they're just leaving it up to the executor to make a good faith effort to notify. But during the 7 months, you can't make any distributions from the estate until that's passed?
Well, you can make some partial distributions, and it depends, right? So, for example, let's say the decedent was unmarried and had one child, and that child is the executor and the sole beneficiary.
Okay.
And that child has other assets. They are solvent. And they say, I'd like to just distribute it and close out the estate account. This is just a hassle for me. And I say, well, the 7 months hasn't gone by. You've made a good faith effort. We don't really think there's anything out there, but you understand that if you do this and something does pop up within 7 months, you're personally responsible.
Right.
But sometimes, so most people say, okay, fine, I'll just wait. But what about if you have an estate where there's $1 million and there is just no conceivable way that there could be a creditor claim for more than $500,000? There's just no possible way that could happen.
Right.
Well, maybe the executor could choose to make a partial distribution, of $500,000 and then hold off and wait for the creditor claim period it's case by case. And
Sure.
I'm going to say usually the people who most want the premature distributions are the cases where you most should not make premature distributions.
There you go. I love that because there's not a lot of money to go around and it'll probably be spent right away. And then the creditor can sue them. come after them, right?
Right.
Got it.
And
yeah. Okay. Awesome. And in that same vein, right? Some of these we get people reaching out to us all the time asking us about, they want to sell a house, right? And can I sell this outside of probate? Like how, can you do this? So in New York, is that can you sell a house outside of probate?
Yes, but no. Yes, you can. So in New York, first of all, I think this might be general or New York, but we use the phrase real property vests at death.
Mm-hmm.
So if your mom passed away without a will and left, unmarried, 2 kids, really the moment that mom passed away, the 2 kids become the owners of that house.
Okay.
But how do you change the deed?
Right. Title transfer is a big thing.
Right.
Yeah.
And I know in some states, like I just learned that apparently in Tennessee, you can do it, or, the child can just do it on their own or something. But in New York, there's a sort of simplified procedure from a full probate where you can ask the court for authority to transfer the deed from mom to her kids.
Okay.
So that is something that can be done. If you want to sell it, there's something called an heir at law transfer.
Okay.
Where the deed goes from, Nancy and Jack as the sole heirs at law of the decedent to the buyer.
Okay.
Now, title companies hate this. So if your buyer is getting financing or wants title insurance, they're going to hate this.
Yes.
If they will accept it, they typically will want the decedent to be dead at least 2 years. This is not a law, but this is from experience.
Title insurance companies run the real estate transaction world, bottom line.
Because they're insuring, they need to underwrite it. They need to be comfortable that they're not going to be responsible for a whole mess.
Yep.
And every once in a while, something crazy slips through title, and I'm like, wow.
I'm doing a title claim right now on a property we bought a month ago. It was a tax issue that we just crazy, right? But I'm having to file a title claim on a property. It happens.
So if your title company is willing to entertain the idea of an heir at law transaction, then they will typically want the decedent to be deceased at least 2 years. The longer, the better. I did an heir at law transaction where the decedent had been gone for 50 years.
Okay.
It was a father and son were both on the deed.
Uh-huh.
And the long story short, dad had died 50 years ago.
Okay.
And the title company, we didn't want to probate that estate.
Sure.
And the title company was very comfortable with that transaction.
Yeah.
We typically will need to present at least 2 affidavits of heirship,
right,
by people who knew the decedent, and they need to be fairly fleshed out. How did you know them? How did you know the other people? Et cetera. The more, the better.
Yep.
So it's possible. It's most possible if it's a cash transaction. If there's no financing. And you're willing not to have title insurance, which I would never advise, but,
Me neither. Having have done 2 title claims over the years, I see the value in title insurance.
I love insurance.
People brag about, I don't buy title insurance. I'm saving myself $400. I was like, you've obviously never had a title claim before. Things happen. Crazy situations happen. I think title insurance is worth every penny. Some people think it's a racket.
I have colleagues who brag about how much money they save not paying for professional liability insurance.
It's like crazy. Or,
First of all, I hope this doesn't come off sounding cocky, but if you need to brag about saving, $15,000, $20,000 a year for your law firm by not having professional liability insurance, you should have other worries.
Sure.
But, we're licensed professionals. And even though I have insurance, I'm still personally liable.
Right.
with my law license. If I mess something up and someone gets a judgment against me for $5 million, and that could happen with some of the work that I do, and mental note, raise my malpractice limits, but right now I have 2.4. My insurance company says we're only covering you up to $2 million for this transaction. They can come after my house. They can come after my stuff personally.
Yep.
Insurance. I don't buy insurance when I buy a computer,
right?
Because I read something once that if you add up all the warranties, extended warranties, right, what you pay for them, if you just always say no, you come out ahead.
Sure. Yeah.
But, that's a computer. That's a washing machine.
But you understand
this is a house.
Risk. It's a risk scenario, right? Worst case scenario, the computer fails, you're out X. It's the same with a car and like car repairs. Like I'm a Toyota guy. I only buy Toyotas because they're reliable. They last forever. They have great resale value or whatever. Every time I've bought one, they always try to sell me on the warranty. I'm like, dude, I've been buying Toyotas for 20 years. I've never, ever, ever had to use the warranty ever. So no, I don't want your extended warranty because I don't need it. And they're like, well, what if this happens? It's like, I have this thing called a savings account. So if my transmission does go out, I have money in my savings account. I'll pay for it if that happens. But based on my experience, it's probably not going to
have $2 million sitting around in your savings account to pay your investors.
Correct. Yes. Right.
I hope you do.
It's analyzing what is my potential, outlay there and understanding that. But yeah, that's crazy. So, speaking of that, if an estate is going to be insolvent and there's claims greater than the assets in New York, is it worth someone's time to even probate an estate at all if you know ahead of time it's going to be insolvent? Most attorneys would still say yes, but
it depends. So, because there are a few kind of priority things. So, first of all, if someone paid for the funeral, the final expenses of the decedent, they can be reimbursed.
Okay.
The attorney's fee, so first you have IRS, right, New York State, taxes, number one.
Yeah.
Actually, there's a few things above that, but in general, taxes, Medicaid, these things. And then there is the funeral expenses, and there are some set-asides for certain types of family members. So if you have a spouse, I believe it's $35,000. It's like the family allowance or something.
Okay.
So the spouse can get $35,000. If there are minor children, or I don't remember if it's under 18 or under 21, they can get something.
Yes.
So I'm actually doing a case like this right now where we did a Medicaid trust and a Medicaid plan, and then the person spent years of their life in a Medicaid nursing home.
Mm-hmm.
But because we had a loophole available to us,
mm-hmm,
all the assets were preserved for her beneficiary. And then but we still always do a will. And we found out that there is an account, and we can't get into the account, so we don't know how much is in there. But there's probably, 50 to 100,000. And we talked about it, and he said, well, look, if I hire you to do this, I'm going to get paid back, right? And I said, yeah. And he said, so if Medicaid comes and makes a claim, and we end up giving everything to Medicaid, at least I'm not out when I'm paying you.
Right.
Exactly. So let's do it. And we don't know. Maybe there'll be more than what Medicaid wants, and maybe there'll be less. But, he's not losing anything. And if, he had paid for the funeral, for example, he could at least get that paid back.
Gotcha. Okay. So there's some, and there's probably, I'm sure, like we have homestead exemptions here in Georgia. Do you guys have that in New York? You don't have that? Okay. Because in some states there's homestead exemptions. So a certain percentage of, if you have a house and a homestead is like exempt from creditors making a claim to that, depending on, your areas. So nothing in New York.
Fortunately, no, it's like the one thing.
Yeah. Well, you got a lot of other great stuff in New York based on what you talked about. There's some cool programs, right?
We do.
And speaking of valuations and insolvency and stuff, are estate appraisals a requirement in New York, or most people recommend them, and some states are not required, but they're recommended? Is that a legal requirement in New York?
It's not a legal requirement. When we file the petition, we have to say we think the estate is worth approximately this much.
Okay.
And that's how they fix the filing fees. But it's obvious that a lot of people are incorrect because they don't have access to information yet, et cetera. So then the fiduciary is supposed to file what's called an inventory with the court, and they don't need to list every asset and the exact dollar numbers, but sort of ranges. So, the decedent had real estate, and it's sort of, A, 0 to 100, B, 200, 100 to 200, sort of, check the box.
Sure.
Yeah. So you don't need to have appraisals. Now, New York estate tax exemption is around $7 million.
Okay.
The federal exemption this year is $13 million.
It's going
so. It is.
Going down.
It is. It's sunsetting at the end of next year. So as of 2026, it will be, I think, right around 8 million, just something like that.
Yeah.
Because it's indexed for inflation, but it had a big bump. All tax provisions have to sunset after 10 years. That's a requirement. So Congress will need to go back, and my colleagues and I think that they're going to stick with the 8 because we need money. So we, as in the United States of America, need, that tax revenue. And,
the reality is the average American probably doesn't even have $8 million in assets, right?
Absolutely not. Absolutely not.
So it's
apparently this year and the last few years, when the federal exemption is so high, they've been reassigning people at the IRS that do estate tax audits to do other projects because they don't have enough work.
There's enough work.
There aren't enough of these estates. So anyway, so what I'm saying is, if your estate is not taxable, most likely you probably don't need a formal appraisal.
Okay.
I suggest when real estate is inherited and it's not being sold right away, it's going to be held. I do suggest they get an appraisal, because when you inherit an appreciated asset like a house or brokerage account, when someone passes away, whether it's through a will or trust or however it is, you get what's called a step up in basis. I don't know if the viewers will understand this, but this is super powerful.
Yes, it's great. I've done videos on it. Yes.
Especially in New York City, I have people, working class people, hospital cafeteria aide, bus driver, bought a home for $60,000, paid for it, worked 2 jobs, etc. That house is now worth $3.5 million.
Yep.
Okay. And they came to me and they said, well, we're getting very old and we might need Medicaid and we don't want probate. So can you transfer the deed over to our son, please?
No. No.
My heart just jumped out of my chest.
Stop.
I was like, you are saying that you want your son to pay $1 million in taxes when he sells that house.
Right.
So I strongly encourage people to use trusts instead of lifetime gifts. So yes. When the original purchaser passes away, there's a step up in basis. All that gain is wiped out. But if the beneficiary, the heir, is going to hold on to that real estate, I do recommend they get a licensed appraisal, because if they want to sell it in 10 years, we know exactly what the value was, when you inherited it. You don't have to get a historical appraisal, which will be more expensive.
Yes. Yeah, and you know what that basis was then. And what most people don't realize, and I did a podcast with my CPA about this. Some people might actually have a capital loss, because if it steps up and you immediately sell that property, as long as we're not in a rapidly appreciating market, when you factor in the selling costs and stuff of selling the property and what your basis was on the date of death, and then let's say you sell it 3, 4, 5, 6 months later, you paid a real estate agent to sell it or whatever, you fixed X, Y, and Z, you might actually have a loss than a gain, right? So, yeah, most people don't even realize that. So,
yeah.
Awesome. Yeah. Well, that's great. So, in that same vein about, selling a house, we talked about that, selling outside of probate. What about I'm in a little a probate help group on Facebook, and someone posted about this today about, hey, my mom died. She only had a car. That's the only asset she had, and she had a few $1,000s on her bank account. Do I have to probate that? So in New York, do you guys have small estate?
We do.
Provisions?
So in New York, a small estate is now under $50,000. It used to be 30, now it's 50.
Okay.
It is supposed to be a simplified process. I will tell you right now that my office charges $3,500 to handle it because it's never simplified. It's never really simple.
Sure.
It's never really simple. There is great software available online that the court provides for self-help.
Okay.
And there is an office in the courthouse, at least in New York City, where you can go and they do have actual volunteer attorneys who will actually answer questions. Now, as my dad says, you get what you pay for or less. Right. A lot of them are, not super experienced, but yeah, absolutely go try it yourself. If you have the energy to do it yourself, go ahead and do it. The clerks tend to be more helpful with small estates, even though they're not supposed to be.
Right.
And if you have a car that's worth under $25,000, you can just transfer it to next of kin through the DMV.
Okay.
You don't even need to deal with that. And there's also a process. I think we call it oh my gosh, I forgot the site, but there is a provision under New York law where if there's an amount of money in a bank, so it doesn't work for everything. It works if it's like a deposit account, so a bank or a brokerage account, something like that. And either you paid for the funeral or you're the spouse or the child, you can fill out this affidavit that we can prepare for you, or you could find it online. And if you're going to do this, you could try to do it yourself. It's not going to hurt you. Right. And you give it to them. And after a certain period of time, they are supposed to turn the money over. Okay. It's hard to get it done because it's a little esoteric. It's a little weird. It gets on the wrong person's desk. But if you don't want to go through the small estate proceeding, it might be worthwhile.
Okay, cool. Well, that's great information. Well, Yana, you shared so much stuff today. And I mean, just you're a wealth of knowledge for New York. We probably need to come back and do another episode and have you talk about, more stuff, right? And love to have you as a contributor, on Probate Resource if you'd love to contribute some written articles and stuff like that. So if someone is for a real estate agent or real estate investor, because you mentioned you work with kind of both parties, right? If they were interested in working with you, and we talked about this off camera, and this was a great piece of advice, and I don't want to leave this out. If they want to work with you, what tips would you have and some things they need to keep in mind?
Okay. So I actually really like working with real estate investors and developers, partially because it's in the family. My husband is an architect and he does real estate development and investment, and, we have our finger in a few projects. Sure. So I'm familiar with that world and obviously know people. First of all, I think it's great to create a relationship and, talk to other people that are doing this and ask them, do you have a good estate attorney that you've worked with? Would you introduce me? Someone that you've had a positive experience with. And and this happens to me once in a while, and I always appreciate it. Someone reaches out to my office and says, hey, my name's Matt. I'm a real estate investor, and I sometimes have situations that need an estate attorney. I'd love to schedule some time to speak to Yana about it. Right. And we get on a call, we get on a Zoom, 15, 20 minutes, kind of sniff each other's butts. Do you like me? Do I like you? Do we feel trustworthy to each other? Is this someone that I'm comfortable doing business with? Because in both directions, it might not be a good fit.
Exactly.
Right. And one of the things that I always tell my real estate people is, and then when they have matters for me to work on, I like it because they've kind of done the preliminary research. They've done the preliminary footwork.
Yep.
They're, especially the ones that I've worked with more and more, they're more and more experienced. They know more what questions to ask, et cetera. So they come to me with more information. So it just makes my life easier. And there's already a relationship with them and the client, that they're feeling comfortable and, that, we're working towards a mutual goal. But what I tell my real estate people is it's not, if it ever becomes not a mutual goal, I have to pick sides and I don't pick your side. You might bring me the case, you might be paying my fee. And typically what that often, sometimes the family has money and is able to pay my fees, and that's great.
Sure.
Oftentimes they don't. The only value is in the real estate. Yep. And then the real estate investor will, front some of the money, or the family will, gather a little bit together. We work on, we figure out how to make it work. Yep. And I put in the retainer agreement, in the engagement agreement, that, Mr. Smith, son of Mrs. Smith, you are my client. As of right now, you're authorizing me to talk to Joe, the real estate investor who wants to buy your house that introduced us, but you can retract that at any time. If there is any conflict of interest, I do not represent this real estate investor. I represent you. My duty of care and loyalty is to you. And this is a story that I was going to tell you. A real estate investor that I've worked with many times over the years. And sometimes he brings me cases, and sometimes I reach out to him and I say, hey, I have an estate. It's a shambles. We need a quick sale. They want money. Come take a look. You see it, you like it. Good for you. And, because we could have gotten more if we waited, if we got some. It's such a disaster. There's no C of O. There's no end user who's going to buy it without financing.
Right.
So we need that.
The investor is your only buyer. Yeah.
Right. Or, the place is under a demo order, full of squatters, whatever it is. So he came to me and said, this gentleman wants to sell his house, but he's on Medicaid and he's concerned about Medicaid eligibility. So because I happen to have both the estate and the Medicaid information, it was a really good fit. But when we dug into it, we realized that they thought the gentleman had a mortgage on his house. House is worth $1 million. They thought he had an $800,000 mortgage.
Right.
And that he was selling it because he couldn't afford to pay the mortgage.
Okay.
Fact is, he had a reverse mortgage.
Oh.
But the thing with the reverse mortgage is you get to stay in that house until they carry you out feet first.
Yep.
And they have to pay for your insurance, and they have to pay for your property taxes if you can't, because they're not going to let it go to foreclosure.
Mm-hmm.
Right? And this gentleman's only income was $330 of Social Security.
300.
And that's, there are things that I'm going to just suggest to him just as a little pro bono thing, because he should be getting SSI too, but whatever.
Sure. Right.
And I said, guys, if he sells you this house, he's going to have to pay off the reverse mortgage, which they always tack on extra fees and costs.
Yes.
He's going to have to pay capital gains taxes. He's going to walk away with zero if he sells you this house for $1 million, and he's going to be homeless.
Yep.
So I have to identify this to him and alert him to this. And, but what I came up with is, what if instead of him staying there and, using up the rest of the equity, while he's alive, if he did a kind of cash for keys deal with you,
mm-hmm.
You deal with the reverse mortgage lender, but don't give him cash. Give him lifetime occupancy in a property.
Yeah, life estate. Yep.
I don't like a life estate because you can sell a life estate or you can rent out a life estate. Lifetime occupancy.
Okay.
You have the right to live in this unit for the rest of your life, and we will pay the common charges and the whatever.
Yep.
And when you're going to and look, this gentleman was not very sophisticated.
Sure.
Elderly, not very close with his kids, obviously.
Yep.
And I felt like we came up with this idea that is going to keep him safe.
Yep.
And it's not a deal killer.
Yep.
So I don't know if they're going to do it or not. They need to crunch their numbers, but the back of the envelope scribbles. Yeah.
Yep.
Listen, he's 90 years old.
Yep. I had
it's a calculated risk for the investors.
It is. That's all it is. Everything's a math problem. I had a similar situation last year, and I almost never let anyone stay in a house that I buy because it's always a disaster. But we had an older gentleman on Social Security, didn't make a lot of money. He had stage 4 cancer. The guy's probably only got a year left to live, right? And he said, I can go live with my daughter. And I was like, look, man, but I worked out a seller finance situation with him. I said, you sell me the house because there was he needed some equity, right? He needed some money to pay off some medical bills. I was like, you seller finance a house to me. I'll give you a down payment. So there's your cash, right? There's your chunk of cash to pay off all your bills. And I'll pay the bills off for you. That way I know you're not just going to take the money and spend it in Vegas or something, whatever, right? We're going to pay off those bills. And then your payment to me or my payment to you would be X amount a month. But then I'll just have you pay me rent and you can stay in the house until you pass, right?
Like a lease back.
A lease back, essentially. And my owner finance payment to you and the rent you pay back to me is kind of a wash. The only difference is there's, X amount of property taxes for the year. So we'll just have to figure out a way to cover that, right? So you'll pay me it was $50 a month is basically what he would pay me to live in this house. And he gets to stay there until he passes away.
Great.
Right?
Great.
And I get the tax benefit in terms of I can write off take some bonus depreciation or whatever. And I penciled out all the math and I was like, well, this actually works for me. And in this scenario, I would let him stay in the house. But usually I don't do buy and lease backs because they're almost always a disaster. They terrible. But in that one, I was like, okay.
Speaking of disasters, I remembered what I was going to bring up.
Oh, perfect. Go ahead.
Partition.
Oh, yes. I've done some videos about that. Let's talk about that.
I hate it. I hate it so much. Okay. So what happens when you have two people that own a property or are entitled to a property and one wants to do one thing and one wants to do another and they can't agree?
Happens a lot.
It happens a lot. And this is something that can absolutely be addressed with proper planning. But because, we say New York real estate vests at death, if you make a will and say, I leave all the rest and residue of my estate, everything I have, I leave in equal parts to my 7 children. This was a will that I probated. And that means that now all 7 children are owners of this property, even though the deed doesn't have their name.
Right.
And guess what? If you're an owner of a property, you get to live there and you don't have to pay rent.
Right.
Even if there are 6 other owners.
Right.
You don't get it. You don't have to pay rent. So in this family, one brother had been living in the house and he stayed in the house and everyone else wanted to sell the house and he didn't want to. And after 3 or 4 years of him enjoying living in this house, and he was, to be fair, he was paying taxes.
Sure.
I don't know if he was paying insurance because I don't know, but he was paying taxes. We brought, this was years and years ago. It was my first experience with it. we brought something called a partition action, where you go to the Supreme Court, not the surrogates court.
Right.
You go to the Supreme Court because we're dealing with live people, right? It's the 7 siblings that are the owners. Dad's out of the picture now. He's gone.
Yep.
And we say, 6 people want to sell, 1 person doesn't, but there's no majority wins here. So we're asking you to bring a partition. We're asking you to partition the property and allocate it between the owners. And in that process, that case happened to settle. And by the way, it settled with the single largest amount of cash money that I've ever seen in my life.
Really?
All of the siblings ran small businesses.
Okay.
And when they went to buy out their brother in the end, they basically showed up with $500,000 in cash between them. And I did it at a local bank. I called them up and I said, listen, can we meet there? And,
yeah.
Anyway, but as part of this partition action, the court will order the property to be sold and the proceeds divided.
Yep.
A partition, I tell people, budget at least $40,000 and 2 years. And that's a best case scenario. And if I were you, I would do renovation math where you double your budget and double your time.
Yes, exactly. Yes.
So
for sure.
I don't personally handle them. We have a real estate litigator
right.
in our firm who does, but it's, again, with proper planning, you can avoid this.
Yes.
But when it's a last resort, it's a last resort. Now, there's sometimes you can bring a proceeding called a turnover proceeding in the surrogates court.
Okay.
And I don't know if this is unique to New York or not. So here we're saying that an estate's been opened.
Mm-hmm.
The property belongs to the estate. Someone is living in the property, right? Now, if someone went and took a painting that belongs to the estate and brought it to their house, and I'm the executor and I say, give me back that painting, it doesn't belong to you, it belongs to the estate, and they won't do it, I can bring a turnover proceeding where I say, surrogates court, judge, this bad person took this property that belongs to the estate, you need to order them to return it.
Yep.
So sometimes we have used that mechanism to get someone out of a property. Instead of an eviction, we bring a turnover in housing court, we bring a turnover proceeding in surrogates court, and we say, judge, because this grandchild moved into the house, it's like they're holding an asset. We can't show the house. We can't sell the house. I mean, you could sell it at a deep discount to someone that's never been inside and they'll deal with it, but that's not fair.
I'll buy them like that, but I tell them, you're going to pay for it because I've got to deal with this now. I've got to evict them, and it's going to take me months. It costs me $1,000.
And I've had judges order an ejection, which is different from, I might get the terminology a little wrong because I'm not a housing court person, but basically the judge puts the person out, but they don't have all of the relief that you have in housing court.
Okay. And
they'll literally say, you're out in 30 days, and if you're not, the sheriff's coming.
Yep.
So it only works in very specific cases. Like, it wouldn't work if it was a child, and if the estate goes to my children and it's one of the children, but if the will says, I leave this house to my daughter Jackie, and my daughter Susie moves in, that's not her house. You could try that turnover proceeding. So,
cool.
Real estate, estate litigation can be fun too.
Oh yeah, there's so many. Some people are like, "Oh, this is all law. It's boring." It's like, no, this is all there's some very interesting stuff in there, and there's some very interesting loopholes out there, and there's just a lot of interesting stuff. And you've brought so much value today, Yana. I really appreciate all this value you brought. So if someone is...
I really hate talking about this stuff.
You do. I mean, gosh, just terrible. You're like one of those typical attorneys that just, just dry and... No, I'm just kidding. So if someone's in New York City area and they are interested in working with you, working with your firm, what's the best way for them to get a hold of you?
Call us, email us, find us online, send our intake coordinator an email.
Okay.
His name is Alex at yanafeldmanlaw.com. You can go to our website, yanafeldmanlaw.com. Our phone number is there. We have a little inquiry form, and, we'll reach back out to you, and, we will be happy to help. And we do typically charge for what we call strategy sessions, because the first time we sit down with someone, we're figuring it all out. And even if they end up not hiring us, or even if there's nothing for them to do, we've given them that education of what the situation actually is.
Right.
So we charge $500 for that.
That's reasonable.
And if your listeners, if they want to reach out and if they want to mention your podcast, we'll knock a little something off.
Okay. Awesome. That's great. Love it. Cool. Awesome. Well, we'll put all that stuff in the show notes here. And Yana, I really appreciate your time today. We'll have to, get back together and do some more of this stuff, because this is so interesting. And obviously you love what you do. And maybe we'll do an episode with our mutual friend Josh. Maybe we could do that.
I would love that.
Yeah. So awesome.
He's great. I've learned a lot from him.
Good stuff. Well, thanks so much for coming on. I really appreciate your time. And guys, that concludes our episode of the Probate House Guy podcast. I am Brad Woodall, the Probate House Guy. Like I mentioned in some of the other episodes, if you're interested in getting into the probate niche of real estate, I offer a done-for-you marketing package where we will handle all of your marketing in terms of getting more probate deals and doing more probate deals. If you want to learn more about that, go to probatehousiguy.com. And if you're interested in getting a hold of Yana, you can find her information in the show notes. Thanks again, Yana, for joining us today, and I hope you have a great day.